2 days ago, something happened at the Supreme Court of the United States that may affect the future of immigrant families across America. And the most surprising part is that many people do not even realize it took place. On April 1, 2026, 9 Supreme Court justices gathered to consider one question that could decide whether a baby born here on American soil, inside an American hospital, is still recognized as an American citizen or not. And I am about to tell you something that may truly surprise you. 6 of those 9 justices, including some appointed by Trump himself, looked straight at Trump's lawyer and essentially said, "We are not convinced by this argument." President Trump himself was present in that courtroom, becoming the first sitting president in American history to attend a Supreme Court oral argument. He remained there for 90 minutes. He watched. He listened. And what he heard from those justices was likely not what he expected. Now, here is why this matters to you directly. If you are on an H-1B visa and your child was born in America, this case concerns your child. If you are on an F-1 student visa, an L-1 visa, DACA, TPS, or if you are undocumented, this case concerns your family. According to Pew Research, 320,000 babies were born in 2023 alone to mothers who were either unauthorized or on temporary legal status. That is 9% of every single baby born in this country. And Trump's executive order would remove citizenship from all of them. Stay with me for the next 14 minutes, because I am going to explain exactly what each justice said, which justices appeared to support immigrants, which one appeared to support Trump, what this may mean for your specific visa category, and the 5 important steps you should take right now to protect your child. Do not skip ahead. Every part matters. My name is Zubair. This is US Visa News Daily, and this is the most important video I have ever made on this channel. Let me begin with the basics, because there is a lot of confusion out there. On January 20th, 2025, the very first day of his second term, President Trump signed an executive order titled Protecting the Meaning and Value of American Citizenship. Now, that title sounds honorable, but let me explain what it actually says. This order directs every federal agency in the United States to stop recognizing automatic citizenship for any baby born in America unless at least one parent is a United States citizen or a lawful permanent resident, meaning a green card holder. Think about what that means for a moment. If both parents are on H-1B work visas that the United States government itself approved, and their baby is born in a hospital in New Jersey, in Texas, in California, under this order, that baby would not be recognized as American. If both parents are international students on F-1 visas, and their baby is born during their studies, not American. If the parents are DACA recipients who have lived in this country since they were children, their newborn baby, not American. If the parents are asylum seekers, TPS holders, or people with pending green card applications whose paperwork has not been finalized yet, their babies not American. According to immigration experts, between 5.5 million and 6.5 million people currently living in the United States fall into these categories. And every year, approximately 255,000 babies would be born without American citizenship if this order goes into effect. Over the next 20 years, that number could exceed 750,000 children. Now, here is the critical thing to understand. This executive order has never gone into effect, not for a single day. The very first federal judge to review it, Senior U.S. District Judge John Kochenauer in Seattle, called it, and I am quoting his exact words, blatantly unconstitutional. Every single federal court that has heard this case has blocked it. Every single one. And that is exactly why it ended up at the Supreme Court. Now, let me take you inside that courtroom on April 1st, because what happened there is remarkable. At 9:47 in the morning, President Trump walked into the Supreme Court. He sat down in the front row of the public gallery on the south side of the courtroom. Next to him was Attorney General Pam Bondi, Secretary of Commerce Howard Lutnick, and White House counsel David Warrington. There was no announcement, no fanfare. He simply sat there with his hands clasped in his lap. According to reporters who were present, Trump barely moved for the next 90 minutes. He leaned forward once at 10:12. He looked toward the press section at 10:47, and at 11:20, about 90 minutes in, He stood up and quietly left. But during those 90 minutes, here is what he heard. The government's lawyer, Solicitor General D. John Sauer, stood before the 9 justices and argued that the 14th Amendment Citizenship Clause was originally intended only for newly freed enslaved people after the Civil War. He argued that children of temporary visitors and undocumented immigrants were never meant to be citizens. He argued that birth tourism is a growing problem and that the United States should align with other countries that do not have birthright citizenship. And then, one by one, the justices pushed back. Chief Justice John Roberts, a conservative appointed by President George W. Bush, challenged Sauer directly on the birth tourism argument. He asked how common it actually is. Sauer admitted, and I am quoting, "No one knows for sure." Roberts then asked whether birth tourism has any impact on the legal analysis before the court. Sauer tried to argue, "We are living in a new world." And Roberts delivered what may be the most important line of the entire hearing. He said, and listen to this carefully, "It is a new world, but it is the same Constitution." Let me repeat that because it matters. The Chief Justice of the United States Supreme Court looked at the president's own lawyer and said, "The Constitution has not changed just because the world has." Justice Neil Gorsuch, also a conservative, appointed by Trump himself during his first term, was equally skeptical. He pointed out that when the 14th Amendment was ratified in 1868, the United States did not have strict immigration laws. Anyone could arrive and establish a home. Gorsuch then cited a lecture by Justice John Marshall Harlan, who had dissented in the original Wong Kim Ark case in 1898, in which even Harlan admitted that under the court's ruling, the child of English visitors in the United States would be a citizen. That directly contradicts the government's position. Justice Elena Kagan told Sauer that the Wong Kim Ark case had a very clear rationale. There was a historical tradition of citizenship by birth that carried over into the 14th Amendment, and it came with no limitations. Justice Brett Kavanaugh, another Trump appointee, dismissed Sauer's argument about what other countries do. He said, and this is a direct quote, "We try to interpret American law with American precedent based on American history. Why should we be thinking about the many other countries in the world that do not have this?" Kavanaugh even suggested that if the court simply followed the traditional understanding of the Wong Kim Ark precedent, then this is a short opinion. The audience in the courtroom actually laughed. And then Justice Sonia Sotomayor raised something that should deeply concern every immigrant in America. She reminded the courtroom that when the Supreme Court previously ruled that Native Americans could not become citizens, the government went back and denaturalized people who had already become citizens. She looked at Sauer and essentially said, "Under your logic, what stops a future president from trying to apply this retroactively? What stops them from going back and challenging citizenship for children who were already born and already recognized as citizens?" Sauer said the administration was only seeking to apply the order going forward. But here is what he did not say. He did not say that retroactive application would be unconstitutional. He did not say it could never happen. He left that door open. Now, to truly understand what is happening, you need to know about one man. His name was Wong Kim Ark. He was born in San Francisco in the 1870s to parents who had immigrated from China. Under the laws of that time, Chinese immigrants were explicitly barred from ever becoming United States citizens. They could live here, they could work here, but they could never become citizens. Wong Kim Ark traveled to China to visit family. When he returned to San Francisco, immigration officials stopped him at the port and said, "You are not a citizen. You cannot come in." The case went all the way to the Supreme Court. And in 1898, in a landmark 6-2 decision, the Supreme Court ruled that Wong Kim Ark was a United States citizen. The court said the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, including all children here born of resident aliens. That case has stood for 128 years. No court has ever overturned it. No president has ever successfully challenged it. And the Trump administration itself acknowledged during Wednesday's arguments that it was not asking the court to overrule Wong Kim Ark. The lawyer for the challengers, ACLU National Legal Director Cecilia Wong, called that a fatal concession. If the government is not willing to overturn the precedent, she argued, then the precedent controls. And the precedent says, if you are born here, you are a citizen. Now, let me speak directly to my audience. Many of you watching this right now are on H-1B visas. You work at Google, at Microsoft, at Amazon, at hospitals, at universities. The United States government approved your visa. You pay taxes. You contribute to this economy. And your child was born in an American hospital. Under Trump's executive order, your child would not be recognized as American. Let me be very specific about who is affected. If you are on H-1B, H-4, L-1, L-2, F-1, F-2, J-1, J-2, O-1, TN, E-2, DACA, TPS, asylum pending, or if you have a pending green card application that has not been approved yet, your baby born in the United States would not automatically be a citizen. And here is something most people do not realize. Immigration status does not automatically pass from parent to child at birth. If you are on an H-1B visa, your baby is not automatically on an H-1B visa. Right now, your baby is an American citizen, but under Trump's order, your baby would be born with no status at all. You would have to separately file paperwork to obtain some kind of visa for your own newborn child. And if that paperwork is denied, your baby could technically be considered removable. A baby born in an American hospital considered removable. Justice Sotomayor herself raised this exact scenario during the hearing. She said, and I am quoting, "If allowed to take effect, the order may even wrench newborns from the arms of parents lawfully in the United States. Some children could even be rendered stateless. If the parents are refugees who fled their home country, registering a child with that country's government could be dangerous or impossible. The child could end up with no citizenship anywhere on earth." So let me give you the scorecard. Based on the oral arguments on April 1st, here is where each justice appears to stand. Clearly skeptical of Trump's order, meaning they appear to lean toward immigrants. Chief Justice Roberts, Justice Gorsuch, Justice Kagan, Justice Sotomayor, Justice Jackson, and Justice Kavanaugh. That is 6 justices out of 9. Justice Amy Coney Barrett asked pointed questions to both sides, particularly about what happens to abandoned babies under the government's rule. She seemed unsatisfied with Sauer's answer. Her position is uncertain, but she appeared to lean toward skepticism. Justice Clarence Thomas asked questions focused on the domicile issue. His position is harder to read. Justice Samuel Alito was the only justice who appeared to openly support the government's position. He pressed hard on the fact that the word domicile appears 20 times in the Wong Kim Ark decision. So, the realistic count right now, at least 6 justices skeptical of Trump, possibly 7, 1 uncertain, and 1 leaning toward Trump. But, and this is critical, oral arguments do not always predict the final outcome. The justices ask difficult questions to test arguments, not necessarily to reveal their final views. The decision will come by late June or early July 2026. Until then, the executive order remains blocked. No baby born in the United States is being denied citizenship right now. But what if I am wrong? What if the court surprises everyone? Let me tell you what could happen. Babies born in the United States would no longer automatically be recognized as citizens just because they were born here. Parents would need to prove their own citizenship or green card status to the federal government before their newborn could be registered as a citizen. Right now, hospitals help parents file for a birth certificate and social security number. That process assumes the baby is a citizen. Under Trump's order, that assumption disappears. 40% of all births in America are covered by Medicaid. To enroll a newborn in Medicaid, you need a social security number. To get a social security number, you need proof of citizenship. If that proof is no longer automatic, newborn babies could face delays in health insurance in the very first days of their lives. And remember what Professor Amanda Frost of the University of Virginia said. If the court agrees with Trump's legal theory, it is not just a new rule going forward. It is a declaration that the 14th Amendment has been misunderstood for 158 years. That means, in theory, Even people who are already born and already recognized as citizens could have their status questioned. She said, and I am quoting, "If the citizenship clause has meant that the children of temporary immigrants are not citizens, and my great-great-grandfather was a temporary immigrant, then I would not be a citizen." Now, the good news is that right now, today, the executive order is blocked. Your baby born in America is an American citizen. But you need to be prepared. Here are 5 things every immigrant parent should do immediately. Step 1. If your child was born in the United States, apply for their United States passport right now. Do not wait. A passport is the strongest proof of citizenship. Go to travel.state.gov and apply. If you already have one, check the expiration date. Renew it if needed. Step 2. Get a certified copy of your child's birth certificate from the state where they were born. Keep the original in a safe place. Make digital copies. Store them in the cloud. If you ever need to prove your child was born in America, this is your first line of evidence. Step 3. Apply for your child's Social Security card if you have not already. This establishes a federal record that your child exists as a recognized person in the United States system. Step 4. Consult with a qualified immigration attorney. Do not rely on YouTube videos alone, including this one. I am giving you information, not legal advice. Every family situation is different. An attorney can review your specific visa status and tell you exactly what your options are if the law changes. If you cannot afford a private attorney, contact your nearest legal aid society or reach out to organizations like the ACLU, the American Immigration Lawyers Association, or the National Immigration Law Center. Step 5. Monitor the Supreme Court decision timeline. The ruling in Trump v. CASA is expected by late June or early July 2026. Subscribe to this channel and join our WhatsApp community. I will be among the first to cover the decision when it comes out. The link is in the description and in the pinned comment below. I want to end with something that is not getting enough attention. Even if the Supreme Court rules in favor of immigrants, which appears possible, the damage is already being done. Immigration attorneys across the country are reporting that pregnant women are afraid to go to the hospital because they worry immigration agents might be there. Parents are rushing to get passports for their newborns because they are terrified the government may challenge their children's status. Families are making life decisions whether to have children, where to give birth, whether to stay in this country at all, based on fear of an executive order that has never even been enforced. That fear is real, and it is intentional. And regardless of what the Supreme Court decides, that fear may continue as long as the current political environment remains. So here is my message to every immigrant family watching this. Document everything. Protect your children's paperwork. Stay informed and do not panic. But do not be complacent either. The Constitution is on your side today. 6 justices appear to agree, but you must be prepared for any outcome. If this video helped you understand what is happening with Birthright Citizenship, hit that subscribe button and turn on the bell notification right now. I cover immigration news every single day, the kind of news that directly affects your visa, your family, and your future in America. Join our free WhatsApp channel. The link is in the description. I send alerts there before I even upload to YouTube. Over 367 families have already joined. Drop a comment below and tell me, are you an immigrant parent? How does this case affect your family? I read every single comment. And share this video with every immigrant family you know. They need to hear this. This is Zubair from US Visa News Daily. Stay safe, stay informed, and I will see you in the next.